Good evening, everyone. Welcome to this virtual roundtable entitled EU Values are Law After All, a new look at systemic infringement actions. I'm Alex Andriani Moylan from the Leuven Center for Global Governance Studies, and I will be moderating this event. In order to kick off this evening's conversation on Article 2 violations and systemic infringement actions, we will start with a brief introduction by Professor Jan Wouters, who is coordinator of the Horizon 2020 project, RECONNECT. Professor Wouters, you have the floor.
Thank you very much. Good evening, dear colleagues and friends. Allow me to begin indeed with a few words of introduction about our RECONNECT project. As Alex just said, this is an EU-funded Horizon 2020 project. The full name of that is Reconciling Europe with its Citizens Through Democracy and the Rule of Law, bringing together 18 partners from 14 countries. And the aim of RECONNECT is to understand and provide solutions to the recent crisis faced by the European Union, from the most flagrant cases of democratic and rule of law backsliding to the more complex and diffuse disconnect and waning trust between the EU and its citizens. RECONNECT has an explicit focus on developing avenues for strengthening the EU's legitimacy, enabling the Union to become more attuned to the expectations of its citizens. And over the past, say, 2.5, 3 years of our project, we have been at the forefront of key debates on these matters, and I think I may say that we are making a valuable contribution to developing innovative approaches to tackling these issues. Now, despite of the limitations that the pandemic imposes on all of us, RECONNECT is more than ever continuing its work, also through events such as tonight's virtual roundtable, which explores new ways in which rule of law violations, and in particular the undermining of the values of Article 2 TEU, could be fought and prevented. Our panelists will discuss how infringement actions under Articles 258 and 259 of the Treaty on the Functioning of the European Union may be adapted to bring general infringement actions targeting systemic violations of European Union values, thereby helping to turn the EU into a militant democracy. I use the terms militant democracy because this is about, say, the paper that 3 of our distinguished panelists have published, a seminal paper that has appeared in the Yearbook of European Law. The panel will also discuss some very important recent developments, especially, I would say, in the Netherlands, and that's why we're very glad that we have distinguished Dutch panel members. What's going on in the Netherlands? Many things, but I should mention in particular the recent parliamentary debate about the activation of Article 259 of the TFEU by the Netherlands against Poland, but also, and even more importantly and even more recent, the judgment that came out yesterday, delivered by the Court of Amsterdam, a path-breaking judgment where the court refuses to surrender a Polish suspect to Poland because it points to the dangers of a systemic deficiency and of a real danger of violation of the core of the fundamental right of that person to a fair trial. That judgment really comes across as a game changer. I hope an English version will be available pretty soon. So, I mean, these are really great and very important new developments, and it all shows how pressing the topic of today's discussion is. And so, indeed, it's clear EU fundamental values continue to face serious challenges within our very European Union. That's why we are so much welcoming leading rule of law experts from the RECONNECT consortium and beyond. May I quickly just go through the names? We have a sizable delegation, I should say, from the University of Groningen, Professor Dimitry Kochenov, Dr. Barbara Grabowska Moroz, and Professor John Morijn, who is not just a professor at Groningen, but also a commissioner at the Dutch National Human Rights Institute. And then we have joining us from over the Atlantic, from Princeton University, a longtime friend of the RECONNECT project, Professor Scheppele. Very welcome also to our panel. And then we have, last but not least, I should say, Professor Kees Sterk, who is also an academic and a practitioner. He is a professor at Maastricht University and a senior judge in the Netherlands, sharing his insights from the ground, so to say. So thank you all very much for joining us for what I am sure will be a fascinating conversation to which I very much look forward to. And so I now give back the floor to our beloved Alex, who will be moderating tonight's event. Please do stay tuned with RECONNECT and have a very, very good evening. Thank you.
Thank you very much indeed, Professor Wouters. Before we proceed, just a couple of housekeeping matters. As always, we will engage with you, the audience, of course, in our Q&A in the latter part of this event. So please do send us your questions and comments via the question pane in the GoToWebinar control panel. So as you can see, we have indeed a rather stellar lineup. So without further ado, I will give all of them the floor, starting with Professor Dimitry Kochenov, who will introduce tonight's topic. Dimitry, you have the floor.
Thank you very much. It's really always a pleasure to join RECONNECT events and to do work on the rule of law with colleagues in Groningen and elsewhere. So my task tonight is to outline where this topic comes from, and it comes from basically from Kim Scheppele's ideas of how to stop the EU from losing through winning, and then our conversations with her. Our ideas about combining 258 and 259 as two very similar tools to build further on the EU's rule of law arsenal, and then finally the two Dutch colleagues, the amazing events of the end of the last year, when the ideas which seemed utterly theoretical to Kim, Barbara, and me when we were drafting the first version of the paper, which started actually 6 years ago, coming true or almost coming true. We'll hear more about that. So what do we mean by losing through winning? The Commission seems to be minded to win as many cases as possible in front of the Court of Justice. The Commission is very active, it brings infringement proceedings, and it usually does win. In fact, it always does win, but nothing changes on the ground. So then the problem which we see in the Commission's actions as the guardian of the treaty is that, unfortunately, winning doesn't change much. And unfortunately, winning doesn't actually bring about the results which we would expect to be visible in Hungary and also in Poland, among other possible member states which do not respect the basic values of Article 2. So then the starting question of the paper, which we're here to discuss, and the consequences of innovative deployment of Article 258 and 259 is what to do in order not only to win the battles, but also to win the war. Of course, war is probably a bad metaphor, but this is something that is ongoing, because if the union is really drawing in its essence as a union of law on the principle of mutual trust that binds all the participating member states, then the waning away of trust means the crumbling of the legal system. So what we're talking about is of fundamental importance. And losing through winning can be illustrated by really dozens of cases by now, when the Court of Justice, on the Commission's calling, would actually recognize that there is a breach of the rule of law and other aspects of EU law going on in Poland and in Hungary, would state that this breach is clear and demand that those countries stop breaching the law, but it would be too little too late. So in the end, the situation on the ground doesn't change, and the horrible consequences of the breaches, which have been condemned by the Court of Justice, actually continue poisoning the the rule of law environment in those countries and hence in the European Union as such. So I'm about to join the Central European University. That's why this event is co-sponsored with the Democracy Institute. And that's one of the best examples of how the European Commission won a bombastic case in front of the Court of Justice. But when Hungary lost, was exactly 1 year after the library moved, and after everybody, actually almost everybody, besides with the exception of the Democracy Institute, has left Budapest because it was impossible for the university to operate there due to the breaches of the law that we now know are unacceptable and happened to the detriment of Hungarian rule of law and the university. So let me give the floor to my co-authors, who are really the moving force behind the paper, especially Kim and especially Barbara. Kim, the floor is yours.
Okay, great. I had unmuted myself, but turns out there are 2 buttons. So anyway, thank you so much. And I'm really delighted to be here with my Reconnect friends and working on, I think, this really crucial project about, how it is that when you actually have rogue states, I mean, in Hungary's case already, international organizations have classified it as a competitive authoritarian regime, which is to say not a democracy, and Poland is heading there really quickly. And the question is, why hasn't the EU been able to do anything about this slide? So the EU's reaction has been all the way through since Viktor Orban came to power in 2010, and since the peace regime came in 2015, has been to say we don't have the tools. And they keep inventing new tools, and they keep not using those tools. So one of the things we've tried to do in this article is to say they always had the tools. They have always had the tools, and in fact, the tools they had from the start were perhaps the most powerful and most effective, and we think they should use them. So we focus on infringement actions, an old technique in the EU, absolutely not controversial in the treaties, and we focus on it, and we make 2 different sort of adjustments to the way infringement actions have been thought of. So the first is this idea of a systemic infringement action, because the problem with countries like Hungary and Poland is not just that they have single one-off violations of some provision of the acquis, but that they're doing a lot of different things at once. And first of all, the Commission isn't using infringement actions nearly as much as they used to, and the work of a couple of our collaborators, Dan Kellerman and Tom Pavone, shows that the Commission actions are less than half of what they used to be, and I think even less than that by now. So the Commission's just not doing it is the first problem. But the second problem is that when the Commission brings an action against a member state, they tend to make it as specific and targeted and focused as possible. And that way, and this goes to Dimitry's point about, losing by winning, the Commission wins these cases, but the cases can be easily dealt with by the offending country by switching little tiny patches and not changing the system. These are systemic problems in Hungary and Poland, and they need to be met with a systemic reaction. So the proposal here is to say what the Commission should do is to look at a set of things together and realize that this is a systemic change, and to bring an infringement action not just against 1 or 2 small pieces of what the member state is doing, but against a whole array of things bundled together. Because our argument is basically that the whole is more than the sum of the parts. Each individual violation is made worse by the fact that there's so many other individual violations, and that if the Commission goes after one at a time, they wind up being ineffective. So first of all, a bunch of little quantitative violations add up to a qualitative violation. The second is if the Commission even acts and then brings cases to the ECJ will take the cases one by one and fail to see the pattern. And third, what we see is a reluctance to enforce EU law because so many member states are in violation of one thing or another. And there is a big difference between garden variety infringements and these big things happening in states that are on their way out of being democracies altogether. So what we've proposed is to bundle together a bunch of separate infringements and wrap them under a kind of bigger structure. And what's that bigger structure? Well, one thing is to argue that the set of violations rises to the level of infringing EU values. So Article 2, rule of law, we might even get into whether they violate the principle of democracy, but rule of law is the one that we've been working with so far. And then you can combine that with some other packaging elements. I mean, other things that look at the status of the member state in the EU. So, for example, if a member state is violating a whole series of provisions of EU law, maybe they're also in violation of Article 4.3 TEU, which requires sincere cooperation of a member state. After a while, you begin to realize that this is not just like, oops, we forgot to transpose a directive, but this is a concerted effort to undermine EU law, and that should surely be a violation of 4.3. And the reason why you know it is because the set of things packaged together. So this has been our argument, is that the Commission should look to think about things that way, because if they do that, and they take this case to the Court of Justice, the Court of Justice gets a holistic picture and is more likely to realize that EU values are involved. And second of all, if the Commission wins that case, which I think the Commission would be very likely to win these kinds of cases, it gives them much more leverage over what it would take to enforce the judgment. Because you can't just put a Band-Aid on something as you can if it's just a tiny violation of a particular piece of the acquis. The Commission could require coming into compliance with, the entire structure of EU law. And finally, if that judgment of the ECJ is violated, the Commission can go back and ask for even larger fines under Article 260 than they would if this were just a garden variety small infringement. So by packaging these things together, you've weaponized the infringement action to deal with massive violations of the rule of law. And so that's why we've been arguing the Commission really needs to change its strategy. If I can give one example, do I have time to give a quick example? So one of the things that, Hungary, I'm going to talk about Hungary there. So the Commission very early on, when Viktor Orban was first consolidating power, brought an action against Hungary for firing the data protection officer, which they won. But of course, by the time they won it, the fired data protection officer had moved on to other things. There was a new data protection officer appointed by the government, and the government said, you want us to fire the new one? To which the Commission said, oh, no, we don't want you to fire any data protection commissioners. And so nothing changed on the ground. That's what Dimitry means by, they won the case, but they lost the war. The Commission never asked why that first data protection officer was fired. So he was fired because he was trying to enforce EU law, because the Hungarian government, to this day, puts out these things called national consultations, where they collect the political opinions of their citizens. There is no regulation of there's not even a law that regulates these national consultations. Nobody knows what the government does with the data. It doesn't seem to have any of the guarantees of European data protection law. And that's why the data protection commissioner went after the government for doing this, and he was fired. So the government's still doing it. So the Commission should look at that. But it's not just that. There's also a judgment of the European Court of Human Rights that found that a new anti-terrorism police unit created by Orban early in his regime, that reports directly to the Interior Minister, directly therefore to Orban, has, again, unlimited surveillance capacities. The Court of Human Rights already found this. No, there is no regulation of who they can surveil, how long, how they keep the information, or anything. And that was a judgment from 2016. The Hungarian government has not complied. Add to that one last thing that the government, there's more I could add, but I'll just say one more. The government created a whole agency for facial recognition, where they've digitized all the photo ID pictures of Hungarian citizens and are using it with facial recognition software. So anyone who's participated in a demonstration in Hungary knows that you might get a phone call on your cell phone at 3 in the morning, the day after you've participated in a demonstration, even if you've just been a member of the crowd, which is to say Hungary has turned into a police state. They are surveilling everybody all the time with these instruments that have no legal regulation. And the Commission has said nothing. And what you see is that it's the combination of those things. Any one of them could be an accident. They could say, oops, okay, so we'll destroy national consultation data after 30 days or whatever. But you'd still have the rest of the structure, right? And it's the whole structure that makes you think Hungary is in violation not only of Article 16 of the TFEU on data protection, also Article 7 and 8 of the Charter of Fundamental Rights, but because of the combination, It's also a violation of Article 4.3, for example, sincere cooperation, and potentially also a violation of the rule of law because they have these outstanding Court of Human Rights judgments with which they've not complied. So all of that stuff together would make you think that Hungary's really doing something different. And that's the kind of infringement action we have in mind when we think about systemic infringement actions. With that, I'll turn this over to Dimitry and to Barbara.
So I guess now,
Barbara, indeed, you have the floor.
Thank you. I want to concentrate only on one small part of the paper, which discusses all possible aspects of EU values. I want to concentrate on procedural and procedural aspects dealing with infringement procedure, which, to be honest, is not just a typical infringement. It's actually the content of the case shows it's a sort of qualified issue, even of constitutional matter for the whole EU, which makes the European Commission and then the European Court, in fact, constitutional actors, which makes the whole case special also on this matter. So what is at stake is also not only that we win the whole war, but it's also about the style under which we win this this whole win about values. So it's also about European legitimacy. It's also about equality of member states, and what is the factor that will guarantee these two values to be secured is actually transparency of infringement action. You can see many counter arguments made by member states, especially Poland and Hungary, arguing that the European Commission is trying to or looking for arguments which do not exist on the ground in Poland and Hungary. So one of the points which we make in the paper is that all the submissions, all the findings taken during the prejudicial stage, they all need to be available to the public, exactly to make the case more visible, to show all the EU citizens, but also other member states, also for the purpose of 259 procedure if needed, what is the problem with the rule of law in a given member state. On the other hand, you can also look at the transparency of the Court of Justice, which is not perfect even in time of pandemic. We cannot participate in the hearings of the Court of Justice, one of the most important courts in Europe. Even in time of pandemic, those hearings are not available online. It makes the whole justice system done in Luxembourg completely invisible for common EU citizen. So taking all that into consideration, we argue that transparency of this proceedings need to be really enhanced, not only for us as recipients of the judgment, but also for the Commission themselves. And as a kind of example, you can see at the annual report on the rule of law, which was prepared by the Commission, it was possible to organize supranational consultations, using the term from the Hungary, to find what is going on only on very limited scope, and to see what is the state of the rule of law in a given member state. So taking that into account, it's also possible to apply the same standard to the European Commission. I will not discuss in details the quality of the website of the European Commission, which shows the infringement procedure, because it's not visible to anyone. For instance, even for journalists who are being paid for looking for information, they are not able to find anything visible, in fact, on the website. The rule of law does not exist as a separate topic on this website. We also argue that the matter of procedure and transparency is also a matter of good administration, which is one of the basic value, but also fundamental right, according to the Charter of Fundamental Rights. Another aspect of the procedure is also communication. So how the European Commission communicates issues of rule of law. Is it just a very technical press release given by the Commission official, or maybe it's something more? Within the RECONNECT project, we are going to also discuss this matter, how the Commission, how the EU institution should also communicate to make all those basic values such as democracy and rule of law being visible and understandable by people. I think without getting into further details, I will give the floor probably to John and to discuss the current aspects of systemic infringements taking place. Thank you.
Thank you, Barbara. And I think now we're moving on, as you mentioned, to the concrete examples from the Dutch case, starting perhaps with Judge Sterk and then John Morijn. You're still muted.
So this better? Yes, okay. Well, thank you for the invitation to speak this evening. It's an honor and a privilege to say a few words on the subject of this evening. EU values are law after all, a new look at systemic infringement actions. But let me first congratulate Professor Scheppele, Kochenov and Grabowska-Moroz on their important, inspiring paper on this issue. I thank them for their brain power on, in my view, the most fundamental issue for the European Union, how to successfully uphold the values of Article 2 TEU. EU values are law after all is the first part of today's topic. For me, this goes without saying. I am also with the authors of the paper when they say that Article 2 TEU can lead to legally enforceable duties which are not made explicit in the texts of the treaties. Of course, I realize that this stand is enormously opposed by some EU countries. One of their arguments is the claim that the concept of rule of law is vague and ill-defined, and therefore only a political concept. Well, they are wrong. The core of the concept of judicial independence, for example, as part of the rule of law value, is sufficiently clear. No undue influence of state powers on judges in deciding cases whatsoever. In a recent speech at a roundtable meeting of the Standing Committee of Justice of the Second Chamber of the Dutch Parliament, I gave some concrete implications of this core based on the case law of the courts of Luxembourg and Strasbourg, and also on the work of the Venice Commission and the network of councils for judiciary, of which I had the honor of serving as its president. And I add to this that some unclearness is no problem, because there is nothing new or strange in developing legal concepts which are not totally defined for all times and all countries, such as the rule of law, in an incrementing way, step by step. European judges of every legal family are used to this way of working since Roman law. Nevertheless, I hear rumors that the Commission's legal services are not sure whether Article 2 TEU can lead to legally enforceable duties, and that the Commission is hesitant to put the issue to the court in Luxembourg. I myself are confident that the destruction of the independence of judges in some EU member states will force the Commission of their own free will or under threat of Article 259 TEU to put the issue of Article 2 TEU values, such as the rule of law, to the court in Luxembourg. For now, I will just say that I feel, with the authors of the paper, that the issue of Article 2 TEU is of utmost importance for the subject of today and for the nature of the Union in the future. Will the Union remain and truly remain to be based on Article 2 values, or will it just be based on power, with the EU law as an instrument for this power? Now let me go to the second sentence of today's issue, systemic infringement actions. The authors propose the introduction of these actions since the Commission is too reluctant, some would say have become too political, to enforce compliance of Article 2 values. I support this proposal as a way forward in defending a union based on values. An important aspect of the author's proposal is that state claims based on Article 259 TEU must be brought to life. To this respect, there are some interesting developments in the Netherlands. I will now focus on these recent developments. It all started with a motion in the first chamber of the Dutch Parliament, the Senate, on the issue of the conditionality mechanism in the beginning of November 2020, indicating that more then indicating that more than 75% of the members of the Senate was worried about the rule of law backsliding in the Union and asking the government to do its utmost best to protect Article 2 values. This indicated that the issue is very much alive in the Senate. I hear from senators from different parties that they realize that the nature of the Union based on values, the Union of which the Netherlands was one of the founding fathers, is at stake. So they are very much willing to do something, but looking for effective instruments. On 26 November 2020, both parties supporting the government, Christian Democrats and Progressive Liberals, as well as opposition party, the Green Party, in the second chamber of the Dutch Parliament proposed a motion. It was adopted with a more than 70% majority. In this motion, the opinion was put forward that the rule of law is the fundament of the European Union. Furthermore, it's observed that the disciplinary chamber of the Polish Supreme Court is still dealing with disciplinary proceedings against judges, despite the judgment of the Court of Justice of the European Union, and that this is against the law, because these disciplinary judges are not independent. It goes on saying bluntly that the European Commission fails to enforce the judgments of the court, culminating in the request to the government to examine and prepare the necessary arrangements, preferably in cooperation with member states which are of the same opinion, to take Poland to the Court of Justice of the European Union for non-compliance of the duty that rests upon Poland according to the treaties, and to inform the Chamber on this matter no later than February 1st, 2021. On that very day, the Minister of Foreign Affairs sent his response to the second chamber. He wrote that the government shared the concerns the chamber expresses in the motion, but that a 259 action on the issue of the disciplinary chamber of the Polish Supreme Court was not necessary anymore, because on the 27th of January, 4 days before, the Commission had added this issue to the infringement proceedings concerning the muzzle law. He also wrote that he had discussed the possibilities of these actions with 6 other member states, but that the 7 together do not consider such an action at the moment. They feel such an action is only in order in case all other instruments have failed. A rather reluctant ministerial response, I would say, but nevertheless an acceptance of 259 actions in principle. The possibility of engaging in such actions is considered and kissed alive, and will be used as an instrument to put pressure on the Commission to act. I consider this as an important step forward. Until now, it is not known whether the answer of the minister satisfies the chamber. Knowing the members of parliament who submitted the motion, I would say probably not. So they will try to find ways to put more pressure on the government. One of the more creative and potentially effective ways for the chamber is to start concerted actions with the parliaments of the other 6 countries to pressure their governments to start common 259 actions. This idea was put forward by my colleague John Morijn, also here present in the roundtable meeting I already mentioned, and was very much and widely welcomed in the chamber. So now the chamber should start to realize this plan as soon as possible. Realistically, this means after the general election of next month. We have general elections on the 17th of March this year. I end my contribution by saying, first, in principle, 259 actions are widely accepted in the Dutch political arena to protect the rule of law in the Union. The present government sees them as an ultimum remedium and as an instrument to pressure the Commission to act in defense of the rule of law. After March 2021, a new government will come into power. This offers, of course, new possibilities. The second chamber will try to arrange concerted efforts with 6 other member states' parliaments to pressure their governments into 259 actions on the rule of law, in case the Commission remains to fail, for whatever reason, to uphold the rule of law. And that is, I would say, that sums up the developments on this issue in the Netherlands. Thank you very much.
Thank you so much for all of these wonderful insights. And we continue on the same topic with Professor John Morijn. You have the floor.
Thank you very much for inviting me. For me, it's a particular pleasure to comment on an article, or should I say small book, co-written by 3 scholars that I each admire very much. Professor Scheppele described it as a beached whale. And the image of a beautiful animal stranded does not really suit this article, which I view as one of the best pieces written on the rule of law in the last couple of years. But still, picturing a whale stranded on a beach provides a telling metaphor for the current state of play, for 2 different reasons, and I will explain them in turn. First point. First, the beach whale is out of place because, of course, it should be in the water. The size of the whale is the size of the opportunity missed in plain sight by the Commission and the member states. While the whale being stranded also underlines the danger of not using infringement options fully. After all, a beached whale dies quickly because it soon collapses under its own weight. Given that the Commission and member states currently fail to bring comprehensive infringement actions, and since the Commission, as was explained, does not even bother to enforce its own the judgments that it actually won, it is judges who are now forced to do some of the heavy lifting for them. They do that through Article 267, preliminary references. So this raises the question, as long as 258 and 259 are underused, can preliminary references, meaning the cooperation between national judges and the European Court of Justice, be a fully effective alternative to enforce the rule of law? Let me immediately answer that. I do not think so. And this is perhaps counterintuitive after yesterday's ruling of the Amsterdam Court, after it asked preliminary questions to the European Court of Justice and got a reply on the 17th of December of last year. For the first time, a national court in a well-reasoned and fully transparent manner blocked the surrender of a suspect under an European arrest warrant for reason of a risk to a breach of the core of the right to a fair trial in Poland. This was already mentioned by Professor Wouters. It is one of the most consequential rule of law rulings in the last few years. It puts human rights above mutual recognition, something many scholars have advocated. A game changer, yes, but not an alternative to infringement, I argue. It offers only a decentralized and national court-specific answer to a pan-European problem that is much broader than European arrest warrants. Why? Well, this ruling is a product of the courage and principle of national judges, in this case in Amsterdam. For the European Court of Justice, discussing imploding judicial independence in the context of preliminary references raises a particular catch-22, and I witnessed this myself when I actually attended the hearing on this. Why? The ECJ, and I think understandably so, is very mindful of its own position in such cases. How can it face the implications of its own case law that it is a no-go if independent and impartial judges disloyal to the government are disciplined in Poland, meaning they can no longer reasonably function freely without taking Igor Tuleya-like risks? Without then concluding that all Polish judges no longer constitute a court or a tribunal in the sense of Article 267, and therefore should no longer be able to actually ask preliminary questions. Indeed, that would mean that the European Court of Justice, in doing that, would disenfranchise Polish judges from using 267, and it would also disempower itself from upholding judicial independence. And that is one paragraph in this judgment. I think it's the crucial paragraph if you were listening in on the hearing. That is why the European Court of Justice maintains in its 17 December ruling this unsatisfactory hands-off line. And that dilemma remains. So national courts do the dirty work now. Political and practical problems are confronted nationally and bilaterally. So however important yesterday's ruling, and let there be no mistake, I applaud the outcome and even feel some Dutch pride, a centralized, substantively comprehensive and union-wide solution to deal with threats to judicial independence remains necessary. Such a solution can only be achieved through an infringement action dealing with all aspects of the threat to judicial independence. So we still need the rule of law infringement will, and we need it in the water. My second point, the image of a beached will for the current state of EU rule of law protection is instructive for another reason too. For even when it's in the water, a will is different from legal and political creatures surrounding it, such as the internal market law, competition law, environmental law, migration and asylum law. After all, a will is a mammal amongst fish. Put differently, the rule of law is not and cannot be treated as legal or political business as usual. Indeed, the rule of law is more fundamental. The possibility of compliance with any specific legal regime, rule or norm depends on full compliance with every aspect of the rule of law. To put it bluntly, and I know that you expect that from a Dutch man, it is pointless, theoretically, economically, and practically pointless to invest time and effort in developing any union policy without standing unconditionally firm on protecting what is necessary to fulfill each of these policy ambitions effectively, the rule of law. Now, there will be skeptics in the audience tonight, and I've heard that there's quite a few, or those keen to avoid political confrontation, and they may be asking, okay, explain to me why. Okay, well, think along with me. How secure is your investment in any member state going to be without an independent judge in case of a business conflict? How freely and fairly will members of European Parliament be chosen in any member states if public media, through which EU citizens should inform themselves to make a meaningful political choice, are one-sided because they have been captured? How impactful and sustainable is your Green Deal going to be, or how good your new migration policy, if it is likely that whatever you agree on paper, it won't be implemented in some member states, given their current track record that European Court of Justice judgments simply are no longer given the same effect. This is what Professor Kochenov was referring to earlier with the Central European University case, for example. Indeed, no union policy will be sustainably achieved without better rule of law protection. So however politically inconvenient, complex, explosive, or potentially delaying at a difficult time, we need EU institutions and member states to deal with the rule of law above everything else now. That is the key insight that flows from this great article, or should I again say little book that we are discussing, which I endorse. Some will find this a confrontational or distracting message, or perhaps one they will perceive as requiring an about face. So let me finish with some good news and with a special offer. I am willing to be flexible in welcoming you to the Rule of Law Defenders Club. It is fine by me if you want to self-justify or explain switching gears on the rule of law, because in your view, it is necessary to protect the rule of law, to protect the internal market, or to secure your investment, or to ensure the sound financial management of EU funds, or to guarantee implementation of the Green Deal, or to move to proper implementation of migration policy. I'm willing to buy this argument rather than a principled rule of law argument, because in each case you would be right. I conclude. Every union policy fish needs the will of infringement actions in the water. A commission passive on the rule of law is not a guardian of the treaties. A commission this passive on the rule of law is not serious about achieving any of its own priorities. Thank you.
Thank you so much, Professor Jean Morijn, for that wonderful conclusion. And I must say, we've already started to receive quite some questions from the audience. So I think we should start right away with kicking off the Q&A, and then I would invite panelists to just weave in any further considerations, thoughts they would like to add throughout the Q&A. I will start with 2 questions sent by Michiel Luinik. The first is directed specifically, firstly, to the authors of the article, and he asks, aside from those that are mentioned in the article, where do you see concrete possibilities to build a systemic infringement procedure? For example, how do you view the matter of attacks on media freedom and pluralism of this week in Poland and Hungary? And his second question is instead directed at the whole panel, and he asks, where have you perceived, if any, strong arguments by Poland and Hungary in court that have in some cases worked or influenced court cases in the ECJ, and how did it play out essentially? And then I will add a third question from Stefan Swed, who again directs it to the whole panel, and he asks, we're always very much focused on tools and instruments, their effectiveness or their weakness, asking us, prescribing how things could be done better. Why do we systematically avoid the question of political will by the European Commission and some of the member states? Back to the panel, and perhaps we can start with the authors of the paper for the first question, and then open it up to the rest of the panel.
Yeah, I can, maybe I can start. Let me start with the political will question. So this is what we've all been struggling with, those of us who have been working on this question. That one of, a member state, let's take Poland and Hungary because they're the ones that are sliding out of being democracies. Hungary's already out. Every time one of these states does something, somebody from the Commission stands up and says they are, quote, concerned, unquote. Even just happened yesterday with regard to Hungary. And then what you realize is that nothing happens. Nothing has happened for 10 years. Now, little things happen, but like I said, they're little things that are sort of destined to fail because of the way that they're raised. And so this is what actually led us to say, to remind everybody that it's not just the Commission that can bring infringement actions under Article 258. But member states under Article 259. So this is where I'm so glad that my Dutch colleagues have been so successful in persuading their parliaments and also their courts to take matters into their own hands, because we're really dealing with a Commission that is failing to enforce EU law. And we need to make that absolutely explicit. The Commission, I think, is doing that because the Council has also refused to act on virtually anything. So we have this general failure, and 259 is there as a backup because the Court of Justice has been very good about these cases so far. Not Kelmer, we can criticize some things, but on some of these things, the Court has taken big steps. So Article 259 may be a way to get this thing unblocked, and I think that would be a really good thing. If I can just say one thing on the media freedom question, I mean, one of the reasons why the Commission gets hung up, and you can sort of see why they get hung up, is that on many of these questions, the EU law peg is not so clear. So, for example, on higher education, this is one of the issues with CEU. If the EU doesn't have competency, can they bring a infringement action? And they figured out a way, and on media freedom questions, again, the competency is a little bit sideways, though, as John mentioned, there may be some ways to think about it as you need media freedom for other aspects of EU law. Just on the Hungarian case, the Hungarian government opened up a public foundation into which various oligarchs donated more than 500 media outlets, which are now regulated together in this so-called public foundation. And the government gives this public foundation tons of money. So the government is funding all of these government-friendly media organizations, and they are not funding all the things that are either actual journalism or opposition-controlled media. So, there are some creative ways to think about that. State aid, the fact that the Hungarian government exempted these 500 plus newspapers from competition law right off the bat. So even using, conventional single market tools. I mean, you can still get to some of these things. And again, the crucial thing is to package it together, right? Bring it under multiple cases and show that there's a whole series of things the government has done with respect to media and not just this one thing. And that's where you really see that there's something bigger going on than, oops, I happen to violate a piece of the acquis.
If I could pick it up right there, I absolutely agree, of course, with Kim that the 259 is vital here, but we need to look at the mechanics why. So why do we not see plenty of 259 cases on the list of the case law of the court? And why are the examples that we do see ridiculous examples, like cases regarding Gibraltar, like cases regarding the travel of high Hungarian officials into Slovakia, and then when obstructed, that they would claim their free movement of citizens' rights, etc. It's because the Commission usually takes over. So the state can complain, and here we don't need the general political will on behalf of all the member states. One is enough. One state complains and the Commission takes over. Why would the Commission not take over here? It's because the Commission is failing as the protector of the rule of law in the European Union. So 259 action would be started precisely on the expectation that the Commission will fail anyway, and there is nothing to expect if we are the member states interested in the protection of the rule of law because of the existing track record of the European Commission. And if we look at all the key case law of the Court of Justice, this existing track record is actually quite alarming because the Commission is not willing to be minimally inventive in dealing with the law. It means that it doesn't see beyond its own nose. And the now classical case law on Article 19, which is actually the pillar of our contemporary approach to the independence of judges in the context of the understanding of the rule of law, or as an element of the rule of law, is something that the Commission thought would be impossible. So the court was obviously ready, but the Commission was not ready to respond to the readiness of the court. So now Article 259 is absolutely vital in order to stop being basically harassed by the inaction of the Commission that is not willing to move a finger in order to save the Union from perishing under this rule of law pressure. And in this sense, Article 259 obviously is a vital tool in this respect, because also the member state doesn't need to demonstrate any kind of direct concern. So all the wonderful whale stories we heard from Professor Morijn are actually not necessary in the strictly legal field of Article 259, because the member state simply needs to make a claim that the law has been violated. That's it. And direct relation between the violation of the law on the one hand and the position or the situation in the member state on the other, although it's presumed, it's not necessary to demonstrate it. So Article 259 really brings us further. And I stop here.
If I may, I just want to provide two examples which we were asked about. The first one is the topic I used to work on, and it deals with so-called Stockholm Program. So a number of criminal law directives that member states should implement, and one of the topics is access to a lawyer. So there are multiple issues there. So there is access to a court, also the role of the prosecutor office. All of that, at least in the Polish context, it brings all the rule of law backsliding to one point, and it mirrors most of the examples what is really missing in the system. So this could be one case, and you don't have to look for any EU competence because it's a directive, it's regulated under the EU law. You just need to show the broader picture. What's wrong with the courts in Poland? How lack of independence of prosecutor office affects your access to a lawyer. It's all given, it's all written down, so it shouldn't be difficult. And the second example is the one which involves, I would say, the original sin of the Polish rule of law backsliding, meaning the Constitutional Tribunal, which right now it's just a political actor who provides legitimacy to a government, and they provided a judgment saying that a service provider can refuse access to a service or a good on the basis that he does not agree with the statement. It was about a case dealing with a LGBT related poster, and the service providers refused to provide the services, and then the tribunal issued a judgment that this is unconstitutional to impose any kind of fine on such a service provider. So you have access to the goods and services, and you have a constitutional tribunal, and all that issues need to be just linked and probably sent to Court of Justice. If not by the Commission, then probably by the National Court by preliminary reference case.
Should I go first, Professor Sterk?
Yes, John.
Okay. I think there were two questions addressed to the whole panel. One was already addressed a little bit by Kim about political will. I actually would argue that, in fact, most politicians that I speak to are very interested in learning how to act, but they simply don't know which tool to use, because we are in a bizarre situation that we have created a lot of extra tools without actually using the ones that really work. And that is what this article about, the infringement actions. So I have been arguing in my writing that one of the reasons why we seem to perceive that there's a lack of political will is because we look for it in the wrong places. We need to nationalize the EU rule of law debate. Some of the stuff that Professor Sterk was discussing about was about the Dutch Parliament asking the Dutch government to act in the EU setting. It has nothing to do with the EU sphere, only in the sense that the EU government, the Dutch government, is also a member of the Council. So we tend to think about this as a much too abstract sort of form of political will. But I would be very interested in mobilizing the Danish Parliament in front of its own government, and mobilizing the Finnish government in front of. There's really a world to win there. We haven't even really started to scratch the surface on that. And I'm very much a glass half full person. If in a short period of time that Professor Sterk has been describing, there's quite a lot of traction in the Dutch Parliament, and the Dutch political scene is not at all very pro-European or very progressive, you have to realize. I think that example can be copied in different settings as well. So that's, yeah, it depends. The question on political will depends on where you go looking for it. And my advice would be start looking at it nationally, because that's where's the most power. The second question that was also addressed, I think, to the whole panel is, do the Polish and the Hungarian government actually make convincing arguments in court, if I understand the question correctly? I mean, I can speak from some experience. I was in Luxembourg 4 times the last year listening to the Polish government arguing some of its cases. I would not say that they would be very powerful arguments in the sense of European Union law, but they do have the value of realizing and making people who attend there realize how deep the problem is. Because the whole perception that is being verbalized about the rule of law by the current Polish government is completely at odds with the conception that we think of as a rule of law conception in the EU legal sense of the word. The rule of law, according to the Polish government's position, is simply the rule of the imagined majority, and the minority can just be simply set aside. So that's a much more fundamental problem even as the specific topic of judicial independence. And that militates in favor very much of taking a much more forceful approach in terms of these systemic infringement actions. I'm less knowledgeable about the Hungarian government. I do know a little bit from my experience as being a diplomat for 4 years in Brussels for the Dutch government and interacting with the Polish colleagues and the Hungarian colleagues. The Hungarians are much more legalistic. They're much more strategic and smart about how they go about making their arguments. If they every single piece that they are able to track back, or this is how it was done in France, or this is how it was done in Germany. So that's much harder to debunk, and it's also, let's be honest, just confrontational in the sense that you have to go back to your own drawing board and ask yourself whether everything is really that fine in your own country. But that doesn't take away from the necessity of simply addressing very basic 101 issues, that if there's a court ruling that you have to abide by it, and if it's not abided by, that the Commission should simply go back to court and make sure that there's penalties.
Professor Sterk, yeah, you may go.
Yes,
go ahead.
thank you. Well, I just want to add a few observations about the convincing arguments. I was for, I would say, 2-3 years part of a dialogue between the councils, the network of councils of the judiciary, with the Polish council and the Polish minister of, now not the minister of justice himself, but the vice minister of justice. And my experience is that they know perfectly well the situation in the other countries, and they use their knowledge to confuse other people, because quite a lot of people they talk to from the Netherlands or from whatever country have only a limited knowledge of how the system of independence of judiciaries work. And that's what they use. That is what they use. They use this confusion. So they know perfectly well the situation in others. And I think some politicians, also in my country, used to say, you know, we just have to teach them these values because, you know, they've been years under the communists, etc., etc. And my belief, my experience is that this is a wrong assessment. This had nothing to do with that. They just choose to have a different ideology, and they use the words as rule of law, independence of judiciaries, but they give it a totally different meaning than the meaning which is accepted by almost everyone knowing what these concepts are about. So that is, for me, one of the important things which I think judges should do, but also academics should do. Explain to the politicians what is really going on. It is not. It's just not a grow pain in Poland or in Hungary. There's nothing to, you know, demolishing independent judiciary has nothing to do with grow pain towards democracy or towards whatever. It is just another ideology. And I think what I said, that is important to make politicians understand this, because it doesn't go without saying that they do understand it. It takes quite a lot of time before they grasp what is really going on. And I remember a visit of our Minister of Justice 2 years ago to Poland, and he wanted me to come with him, but I said no, because I'm an independent judge and I don't travel in government airplanes. But I said, this and this and this and this will happen. And they will say this and this and this and this. And your right answer should be this and this and this and this. And exactly happened in his conversation with Giobro. And so in that kind, my feeling is that most politicians are willing, but we must give them the instruments to have these dialogues, and we must make them better understand our own concepts. That's what I would say.
Thank you. Thank you very much. Perhaps we can start the second round of questions with a question from Professor Jan Wouters. So I would give the floor to you, Professor Wouters, and then I will add a couple of questions from the audience.
Well, yes, it's just to let's say further deepen the argument with regard to say Article 2 and its scope, and the very question of whether it is litigiable, whether you can have infringement proceedings based upon Article 2, because I understand the argument made in your paper as you're using Article 2, but you're still linking it to a number of other violations. And let me just ask the question. I'm not sure if you have all read the new regulation on the conditionality that was adopted on the 16th of December, and which, to my knowledge, in Article 2 contains for the very first time a legal definition of the rule of law for EU law purposes. And when you read that definition, it's quite striking that, you know, it's not just for me a definition for the application of that particular regulation. It is a definition that basically says what the rule of law in Article 2 of the TEU actually means. It's a very interesting definition, and I really would like us to see early analysis of all the components in that definition, because I really wonder to what extent they have captured everything and what have you. But that's not at stake here. It's sufficiently rich, I would say, to argue that yes, now we have at least a very authoritative legislative statement on what the actual content is of Article 2 of the value of the rule of law, as opposed to what in the past was sometimes being said. I remember a Polish Minister of Justice basically saying, you know, show us what the definition is of the rule of law in EU law, because does it really exist? It's not in the treaty, so we're not violating anything. So now we have something new on the block. And I would like to ask the distinguished authors of this great paper in the Yearbook of European Law, does this make a difference, this new legislative development, for your argument? Thank you very much.
Would you like to briefly reply, and then we go back to the questions from the audience? Does that sound good? Kim, Dimitry?
Perfect. Then if I jump just 1 second, I don't think it makes any difference whatsoever, because this argument about the lack of clarity is not really a sound argument, given in particular the pre-accession history of Poland, because democracy and the rule of law, of course, was one of the Copenhagen criteria. And we have thousands and thousands of pages of documents dedicated to precisely what the rule of law entails in the context of Poland, and by extrapolating it in the context of the EU. So this is where the roots of Article 2 are in the first place. So, and then of course we have the values that come our way via ECHR. We have all the important work of the Venice Commission, of which Hungary and Poland are also members, and where they send sometimes questionable representatives. Whether you legislate on the meaning or not, to my mind, it doesn't actually affect the meaning in any way or in any sense whatsoever. But my co-authors might disagree, of course.
Yeah, well, let me just say, oh, go ahead, Barbara.
I just wanted to agree with Dimitry, saying that probably if Court of Justice ever gets the systemic action, they will probably use their own autonomous rule of law definition, if they have any. Right now, it's just part of it. It's very formal. But what I'm really interested about this regulation are the examples that are provided. What can be treated as a potential systemic deficiency in the field of the rule of law. And one of the examples is the way how prosecutor service does not investigate crimes dealing with the EU funds. It can, again, it's about the Polish example, it can really tackle this matter at least indirectly. So from this perspective, it can be influential, but I don't think it will be a game changer for systemic infringement action. It's much probably more about political will in the Commission and in member states' capitals.
Well, so I want to have this is the glass half full reading of the conditionality regulation. So I agree with Barbara that one of the disappointments of that regulation is that it links conditionality to exercises involving EU budgetary matters. And so it greatly limits the application of the regulation and makes it not unusable, but much more difficult to use. All the more reason to come back into infringement actions, which don't have that limitation at all. But here's why I think, and I'm really glad that Jan pointed this out, the definition of rule of law actually addresses one of the criticisms we make in our article, which was published before this appeared. So, and I have it before me. So it's Article 2 of the Conditionality Regulation. And if I can just say, our criticism was that so far the way the Court of Justice has understood Article 2 is together with Article 19 and only about judicial independence. And our article says, wait a second, rule of law is much bigger. So here's what it says. Rule of law refers to value 2, Article 2. It includes the principles of legality implying a transparent, accountable, democratic, and pluralistic lawmaking process. Wow, we can go after legislation now, right? Legal certainty, which means you can't just keep changing the rules. And this, both in Poland and Hungary now, we have these possibilities of opening up any final judgment of a court going way back. Prohibition of arbitrariness of executive powers. My goodness, that's the whole thing that we're seeing in Hungary and in Poland. Okay, also effective judicial protection. Okay, we've been there, done that, but that's good. Including access to justice by independent and impartial courts. Good. Also, as regards fundamental rights, separation of powers. My goodness, we didn't think that national separation of powers was an EU law matter until now. Here we go. And non-discrimination and equality before the law. So the rule of law shall be understood as having regard to the other union values and principles enshrined in Article 2. So I take this as, if that's where our political will is, the Commission proposed this, the Council and the Parliament have signed off on it. We have this inner regulation. I would want to use that to bolster our claims under ordinary infringement actions, because we have not had a definition of rule of law before. And I think this gives us everything we asked for in our article. It's just that we need to transfer it out of the conditionality regulation where it's so limited by its attachment to the budget, and to say that this is now the announcement of what rule of law means in the EU. So thanks, Jan. I think this is a great opening and I would wholeheartedly agree. And now we're all on record.
And if we look at the structure of pre-accession conditionality documents addressed to Poland and addressed by the Commission to Hungary, among all the other now member states, starting with starting 3 waves of enlargement back, the structure was exactly the same. It was courts, it was parliaments, and it was the executives and separation of powers. This is what the Commission was testing. So this is what is the origin of Article 2, and somehow current case law of the Court of Justice, for all kinds of reasons, and we welcome that case law, totally ignores basically 90% of what Article 2 should stand for when we read it through the rule of law element of that provision. Would we have any more questions, or?
It looks like Alex is breaking up a little bit.
Indeed.
So, okay, yes. There you are.
Apologies. Yes, I hope you can still hear me.
Yes, we can hear you.
You can? Indeed.
Yes.
That's great. Yes, my Wi-Fi is not collaborating, unfortunately. Perhaps I will switch off my webcam.
Yeah. Then you'll just be a disembodied voice.
Be on the safe.
Ghost.
You've seen these jokes about how all these things are like modern seances. Like, are you there? Can you hear us? Please knock if you're there. Alex, are you there?
I'm still with you.
Good.
I'm still with you. And we do have some questions from the audience. Apologies for this. And perhaps I can start with a question from Nikolaos Toliopoulos, who puts forward the idea of a way to improve protection of rule of law in the EU by questioning whether Article 51 of the EU Charter should be abolished so as to allow the possibility for the Commission to bring infringement actions for violations of fundamental rights by member states even if they are not acting in the implementation of EU law and the Charter. And then we have another critical question from Carlos Closa, who says, your proposal of systemic infringement actions is based on a huge assumption. A ECJ ruling will be obeyed by the rule of law violator. But this opens a catch-22 situation. Why a government that violates the rule of law would respect a court ruling that implies a significant change in its behavior of violating the law? Why do you expect an errant government to comply with rulings? And then finally, from Oscar Polanski, he starts by mentioning how Professor Scheppele has suggested that the Commission could ask for penalty payments to improve the effectiveness of infringement procedures. However, the Commission appears reluctant to ask the court to impose penalty payments on states under Article 260 TFEU, as also highlighted by Judge Sterk. So is it likely that the Commission would ask for penalty payments with a broadened infringement procedure if they are reluctant to ask for these payments already as things stand? So back to the panel once again. Who would like to begin?
Well, maybe I can jump in on the Article 260 and back into the political will question. So the answer to Carlos, and hi Carlos, is that there is this provision, right, in the treaties. If you don't obey a decision of the court, then the Commission is supposed to go back for an Article 260 follow-up, and those fines can be crippling. And what I've been arguing is that a systemic infringement action should lead to bigger fines. And I've also proposed, although somewhat more controversially, that right now the way those fines are awarded is, I mean, the Commission has a formula, but it would probably have to adjust that formula if you have a systemic infringement rather than an individual one. But here's the problem. Right now, if you go back for an Article 260 fine, basically they sort of keep a tab, you know, so you're running a daily fine for violations. And sometimes those violations can go on for years, and at the end it all gets settled out, and in general the states don't really pay those fines. So what I've been proposing, this is before the conditionality regulation went into effect, but I don't think the existence of the conditionality regulation should affect this argument. Why can't the Commission go back, ask for a fine, and then ask for that amount to be deducted from the European structural investment funds until such time as the member state complies, at which point the funds are released again, right? That way the default, while the state is in non-compliance, is that it's not getting money. And, you know, Article 260 doesn't say where the funds have to come from. It doesn't say, you know, you have to tell the member state's treasury to pay, right? So if the EU could turn off the tap of money in the amount of the fine awarded by the ECJ, then that would provide exactly the incentive for the member state to get on board with it. But the last question says, so how come the Commission isn't doing this? And we're back again to political will. So we've got at least 3 judgments of the ECJ with regard to Hungary that are not being followed. So Lex EU was one. There's this so-called Stop Soros law, which allows people who assist migrants, which can include being their lawyer in an asylum hearing, to go to jail for up to a year. That's still in effect, even though the Court of Justice has said that it violates EU law. And we just saw in the last couple of weeks Frontex pull out of Hungary because Hungary is still doing pushbacks across the border in direct violation of an ECJ judgment that says you can't do that. And the Commission has not done anything about this. And we have other cases in Poland, which are even, you know, more egregious, where apparently, you know, this disciplinary chamber of the Supreme Court is still operating, even though the Court of Justice has said that it cannot do what it in fact is now doing. So there's a political will issue here all the way around. And so it seems to me that, again, we need to make the Commission realize that people in the EU care. And I think that if we get to member states threatening 259 actions, if we get to things like the Dutch court saying, we're not gonna trust the whole Polish judiciary, let's see what happens if all the member state courts refuse to honor legal judgments from Poland. Or let's see what happens if nobody will honor a European arrest warrant from Hungary because the courts are also damaged. And so basically what happens is that if the Commission doesn't enforce EU law, then the big accomplishment of the EU, right, which is you have a transnational organization that has barred self-help because you have a centralized body enforcing the law. If that body's not enforcing the law, what we're seeing is the reversion to self-help. And if the EU wants that, it will get that, and it's already getting that. So I hope the Commission gets the message. Thank you.
Would anyone else like to come in? We're coming to the end of our event, but if anyone has
like
some...
briefly chip in on the first question, if you would mind, about solving the issue by extending the scope of Article or abandoning Article 51 of the Charter of Fundamental Rights. That's an argument that has some political leverage as well, because also the European Parliament sometimes makes this argument and puts it in its resolutions. I think that, as Dimitry Kochenov pointed out earlier, you don't need Article 51 to extend the scope of European Union law. You just have to give a wide interpretation of what European Union law already is. Look at the Article 19 judicial independence debate. Just getting rid of Article 51 would be a huge federalizing move that would get rid of the whole system of limited competence attribution in an indirect way that the whole union is founded on. And I think that we have just been discussing for an hour and a half how European Commission isn't able to properly enforce the limited competences that it has been attributed. So I don't see any argument why we would extend its competences to do a better job. I think it has plenty of possibilities to do a good job with the current possibilities. So also from that perspective, I don't see any legal reason. Name me an area that is really not covered in any way by union law that is really a properly serious rule of law issue. I think that you can almost always create a link with European Union law. But I also think it would be putting your energies in the wrong type of project here. It's really about mobilizing nationally the political will to do something about the current hesitation, for whatever reason, in the European Commission to acknowledge that it needs the rule of law to accomplish any of its priorities, and that should be the mission, and not embarking on some new project that would be basically a federalizing move.
May I say something?
Indeed, Professor Sterk. Yes.
Yes. I would just like to add some another aspect. I would say one of the better aspects of the Polish and Hungarian crisis is that the judges in Europe are feeling very much European judges and not only national judges, and that they are far better organized than they used to be. And because of very good media possibilities, they are not only better organized, but they are very much in contact with each other. And of course, there are discussions about how to deal with these situations. And so such a judgment as from the court in Amsterdam, you need some, as we say, you need the first sheep to pass the dam, and then the rest will follow. I will not be predicting that this is going to happen, but it might well be, because I think it was well reasoned. It is not only well reasoned, but is also perfectly in line with the judgment of the Court of Luxembourg, and that is, on the one hand, I'm happy with the courage these judges take, but on the other hand, if you start with the arrest warrants, and you start with civil judgments not being appreciated or whatever, it's very difficult to stop this process. And I think we as academics and judges should make this clear to the Commission that this is a very, very dangerous situation, and I don't have the feeling that they are aware of how detrimental this is for the whole European project. It is like concrete rock, or a rot, as we say in Dutch. It's a very slow process, but it undermines the fundament of a building, and you only notice that the fundament is rotten when the building has collapsed. And I think we should take time to explain and make them understand that this situation is now going on, and this is very, very dangerous for the whole project of the Union. Thank you.
Can I add just one more tiny line in full agreement with Judge Sterk and with John Morijn, just in response to 51, just as Article 19 is about the nature of the judiciaries, whether they act in the national capacity or in the European capacity, the same applies, the same duality applies to Article 2, and this is what we argue in the paper. Article 2 is not only about the nature of the Union, it's about the nature of the members of the Union, and it's clearly phrased in exactly this way. So in order to remain a rule of law union of democracies, the Union has to be composed of rule of law respecting democracies, which means that it would be counterintuitive and counterproductive as well to think about Article 2 in terms of any kind of cross-border situations or activations of EU law, which means that by its very logic, inherently to its role in the whole edifice of EU law, Article 2 cannot be taken to be similar in any way to Article 51. So by attacking Article 51, you solve no problem, and you basically deny the nature of the principle of rule of law and democracy in the edifice of the Union as we know it. That's probably my last statement.
Thank you, Professor Dimitry, Kochenov. Thank you all. We're already running a little over time, and so this is indeed all the time that we have for today. But I would really like to thank our wonderful panel for this fascinating conversation, as well as, of course, our audience for joining us tonight. And apologize once again for the technical issues. Of course, please keep in touch with the Reconnect project by visiting our website at reconnect-europe.eu and following us on social media at reconnect-eu on Twitter. We are launching 2 new webinar series. The first focused on the fallout from the COVID-19 pandemic in the context of rule of law and democracy, which will be launched on the 24th of February, entitled, with an initial webinar entitled Power and the COVID-19 Pandemic. And on the 26th of February, we're launching a second webinar series entitled Reconnect Around the World, where we will be exploring the state of democracy and the rule of law outside the bounds of the European Union, starting with a webinar with Kaufman and Haggard, who will be presenting their new book entitled Backsliding: Democratic Regress in the Contemporary World. So please do register for these upcoming webinars. Thanks again for joining us, and we look forward to seeing you next time. Goodbye.
Thank you.